Good morning. Pursuant to the order of reference received by the committee on March 21st, 2016, the committee will now proceed to the consideration of Bill C6, an act to amend the Citizenship Act and to make consequential amendments to another act. The minister should be with us shortly. However, senior department officials are here to discuss the implications of Bill C6, and I would invite Ms. Tapley to proceed with any opening comments that she may have.
Thank you, Mr. Chair. Sometimes in a meeting, I'll joke on a legal question. I'm not a lawyer. I don't even play one on TV. So I think I'd start with, I'm not the minister, and I'm not going to play him on TV. But I do have a few opening remarks. These aren't his, but just a quick, perhaps it would be helpful for the committee, just a very quick overview of what's in Bill C6. And just to highlight some of the key elements of Bill C6, the changes to the Citizenship Act. The first is repealing the national interest grounds for citizenship revocation. And so these are legislative changes that came into effect on May 2015, which created new grounds for citizenship revocation that allowed citizenship to be taken away from dual citizens for certain acts against the national interest of Canada, and this bill repeals those provisions. This bill also repeals the intent to provide or intent to reside provision. And since June of 2015, adult applicants must declare on their citizenship applications that they intend to continue to reside in Canada, and Bill 6 repeals that provision. Other things that are included in Bill C6, reducing the length of time someone must be physically present in Canada to qualify for citizenship. So to use the vernacular, we've gone from 4 of 6 to 3 of 5. So 4 of 6 years to 3 of 5 years. And to be more precise, the time required to be spent in Canada for citizenship for adults to 3 years or 1,095 days, and from the former or current 1,460 days. And I will stop now, Mr. Chair.
Thank you, Ms. Tapley. Welcome, Minister.
My apologies. I really do apologize. I was held up for unavoidable reasons, but I thought in light of that I could forego my opening statement and just start right in with questions, because I'm almost 20 minutes late. Unless you have a strong desire to hear my opening statement.
Well, I believe that everyone's received your opening remarks in written form, so in consideration of the time, perhaps we can start with the first round. And I would ask Mr.
There's comments, Mr. Chair.
Okay. Minister, a point of order has been raised, and Ms. Rumpel would actually like to hear your opening remarks.
She would. All right. Well, I'll give you an abbreviated form of my opening remarks. Basically, there are 3 elements of this bill that are important to us, to me. One is the issue of revocation of citizenship, and we say that no longer will a government be able to revoke citizenship for terrorists convicted of crimes, because we believe that there should be just one class of Canadian. A second series of issues is about reducing some of the barriers to citizenship which were erected by the previous bill. And the third is about program integrity, to do things which enable the department to maintain integrity, for example, by making it easier for officials to seize documents thought to be fraudulent. So in a nutshell, those are the 3 main rationales for this bill, and I'd be very happy to receive your questions.
Thank you, Minister. Mr. Chen.
Thank you, Mr. Chair, and thank you to the Minister for being here with our committee today. I know that in Bill C6 that there is a change in terms of what is required in the language requirements and the ages to which that applies. And I can share that in my riding of Scarborough North, there are many new immigrant communities, and I've heard the concerns from families that elders and grandparents find it difficult. And under the new rules, the age requirement would see that those between 14 and 17 and 54 and 64 no longer need to fulfill the requirements that were set by the previous government. Can the minister explain the rationale for this decision in light of the context that new Canadians are expected to master one of the official languages?
I think it's a question of balance. I accept totally the evidence suggesting that mastery of one of the two official languages is a good thing, that it promotes and enhances an individual's ability to do well in Canada, to get good jobs, to integrate. So on the one hand, we do favor language requirements. On the other hand, I think for older newcomers, it's less important, and I think one has to take into account cultural issues. I think that for many years, for decades, if not forever, people from countries whose first language is not English have come to this country. Many upon arrival have not mastered the language properly, but almost always their children do, and certainly their grandchildren do, and I don't think that has been a negative factor for Canada over the years. And so that is why we are returning the age range to where it was, so that older Canadians, well, I don't regard 54 to 64 as super old, but those above the average age will not necessarily be required to do this, even though as a general principle we believe that mastery of English or French is important for the success of newcomers.
So individuals that do apply for citizenship, they're required to achieve Canadian benchmark level 4 using third-party assessment results. What does that benchmark level require of the candidate?
Perhaps Katrina Tapi can answer that more specifically. It requires a pretty basic level of English, but perhaps you could describe more specifically.
As the minister had said, it's a pretty basic level of English or French. So it would include things like how to give or follow directions, how to be able to call 911. A very basic level of conversation would be the hallmarks of Canadian Language Benchmark 4.
Okay. So in addition to the basic ability to speak French or English, there is the responsibility of knowing knowledge of Canada, having knowledge of Canada, and the responsibilities of holding Canadian citizenship. How do those pieces factor into the measure of the benchmark level 4?
Well, there is this book put out describing Canada, and people are expected to read that book, and I think the questions largely derive from the contents of that book, which purport to describe some of the essential features of our country. As I've indicated before, we will be making some revisions to that book, but I think it should be a politically neutral statement of the essence of our country, something that we would expect new citizens to be able to master, and on that they would be required to take this test.
Okay. So with respect to the written component of the testing that's required, some Canadians or new prospective Canadians might still fail that written test. Is there a possibility for individuals who do not pass the written test to meet with a citizenship judge to complete the test orally? Is that a possibility for those who might fail the written test?
Yes, they can write a test a second time, and if that still doesn't work, they're entitled to have a meeting with a citizenship judge.
Bill C6 also allows time spent in Canada as a temporary resident to count towards the residency requirement for citizenship. And periods of temporary residence have been eligible prior to Bill C24 as well. So before the provisions excluding time as a temporary resident came into force, approximately what percentage of citizenship applicants included periods of temporary residence in their application?
About 13%, I'm told. And this, by the way, is a provision which we are super keen to add because we want to court international students in particular, and we think it is absolutely right that they be granted 50% credit for time spent in Canada because that has enabled them to better understand the country.
Mr. Chen, question and answer.
Yes, well, what is specifically the rationale for the 50% time credit? Was there consideration that more than 50% credit would be given for those applicants?
Well, that is arguable. We could certainly have done that. I think to restore the 50% credit was certainly a movement in the right direction. One could argue more, but I think 50% is quite fair.
Okay.
Thank you. Ms. Rumpel, 7 minutes.
Minister, you started your remarks talking about how language mastery is important for the success of newcomers, and I think we both agree on that. I'm just curious as to why the rationale was to lower the age requirement rather than looking at other policy options such as increased programming or different types of programming to assist newcomers with language training rather than simply lower the language requirement age.
Well, already a very high proportion of our hundreds of millions of dollars of settlement assistance does go for a language training. And as I said, it's always a balance in these things. On the one hand, you and I do agree that language mastery is important, but on the other hand, I think one can have exceptions made for older people under various circumstances that can be defended. So that is what we are proposing.
Well, that doesn't quite answer my question. I think that if you feel that the programming isn't working, perhaps that's a better option than simply lowering the language barrier. So the next question follows on to that. We know that individuals in the workforce between ages 55 and 64, which is the cohort that would be affected by this change, they form an important component of the economy. So I'm just wondering if you could tell us the research that you've done on the impact of newcomers to Canada, how many are in that cohort, and the potential impact to the Canadian economy by potential exclusion by lowering the language requirement for this cohort.
Well, I did not say that the program wasn't working. I'm not sure which program you mean, but I said a good chunk of the money we invest in immigrants does go for language training. And my sense is that the number of 55 to 64-year-olds exempt from language is not large, and that historically people in that age cohort have done well, even though in some cases their mastery of the English language or the French language is limited. So I do not foresee there being any significant negative economic effect.
Could you quantify what not large means in the context of that cohort?
8%.
Total number, approximately?
8% of the total would be in that age category.
So what would the total be?
Well, it depends what total you're talking about. If it's 100, 8% is 8. If it's 1,000, it's 80.
Okay. I was just trying to get a sense of quantity. We know that the government has changed the formula on economic immigration versus humanitarian immigration. And I think that that particular percentage is important in the context of the change of this language requirement. So again, I'll ask, was there any consultation that was done that quantifiably shows that reducing the language age is a better policy option than looking at increased or more effective programming on language training services in terms of economic impact?
Well, we are investing tens of millions of dollars in language training, so we did not ask the question, should we invest even more as an alternative to this? We thought it was appropriate to go back to what had been the previous situation and give some deference, if you will, some exemption from the language requirement to those Canadians of a certain age, which had been the case in the past, and we thought it was right to go back to that rule.
So given that there hasn't been consultation or any sort of quantification on looking at different programming options or expanded programming options versus simply changing the age requirement, would the government be amenable to amending the bill or perhaps delaying this change until that research has been done? Because by your own admission, this, I think, is a very important public policy option, granting that language is a unifier that has not been done in the context of the bill, and it sounds like a political decision rather than a quantifiable decision.
We did not have consultations specifically on the economic implications of returning to the 55 to 64, but I'm told neither did the previous government have consultations on the impact going the other way. And so we are reverting to the status quo ante, and our predecessors didn't consult on moving away from it, and we thought it was appropriate, given the language situation of many new Canadians, to give them an exemption, those beyond a certain age.
Well, I always don't look at tu quoque as a particularly good policy response. I would say that with the government's desired change in tone, that perhaps the better solution here is to look at how we can equip newcomers to Canada with language skills so that they can fully participate in the economy and that our economy continues to grow. So again, I'll ask, given this and given by your own admission that this research hasn't been done, would the government consider taking out this particular portion of the bill until this research has been done, especially, Minister, in light of the significant changes that you've made to the economic immigration levels in your immigration levels report?
The answer is no, and I don't think it's an either-or proposition. The language training is still available with or without this change, so those in the 55 to 64 age range who want language training, it is available for them.
Would you say that the language training services are sufficient to meet the needs of the newcomers that are coming to Canada, especially under the Syrian Refugee Initiative, given that we're hearing across Canada that newcomers to Canada through this initiative are having a lot of difficulty accessing language training programs? So again, in the context of this bill, the government has decided to lower the age limit requirement as well as up it on the bottom end, rather than focus on providing language training services for newcomers. And I would argue that this isn't a partisan issue, Minister. This is something that needs to happen.
As I've said, it's not either or. We can have the change in the age rule and availability of language training, which is the case.
Thank you. Ms. Kwan, 7 minutes.
Very much, Mr. Chair, and thank you to the Minister and his officials. Just actually on the language issue, as the Minister knows, Bill C-6 maintains the requirement for citizenship applicants to pass a knowledge test about Canada and one of the two official languages. So for anyone who has taken the standardized test, even in their first language, these tests can often be confusing because the wording or the questions could sometimes be tricky for people. And for many new Canadians, this could be reasonably be considered as double testing because they have to go through the testing twice and not necessarily a true representation of the individual's ability to function or succeed in Canada. I can name of many, many examples where people have succeeded and may not be able to pass this test. So I'm wondering whether or not the Minister would be amenable to amending Bill C6 with changes around the language proficiency requirements so that the issue of double testing could be eliminated.
Well, maybe it's an indicator we got it both right, about right, when I'm told to make the language stricter and less strict. So I think we've got it approximately right. And on your question, first of all, if you fail the test, you can have a second chance. And if you fail it again, you can get a meeting with the citizenship judge. But one thing in your question with which way I agree is that the language in the book is somewhat more complex than it need be. So one of the things we want to do is to make the language in the book more comprehensible to more people than it currently is, and I think that would also impact the tests. If we can make the language simpler and more direct and easier to understand, I think that would be an improvement.
Prior to Bill C-24, what was the language proficiency level?
I'll ask one of my officials to answer that.
Level was the same. It's a CLB4, which means applicants need to understand basic sentences, be able to convey information, basic information.
And was the double testing a new concept under Bill C-24?
I don't know what you mean by double testing, but I'm told the answer is no. What do you mean by double testing?
Well, what I mean by double testing is that people have to pass the proficiency test, and then they have to have an additional testing in terms of information about Canada, right? So that's double testing.
I'm told that change came before C-24.
With the Conservative administration?
Well, perhaps Ms. Tapley can answer to make it perfectly clear.
The changes to requirements to provide upfront evidence of language at the Canadian Language Benchmark 4 level was a change that was made prior to Bill C-24. I believe, Marianne, it was about a year before C-24?
November 2012.
November 2012.
Thank you. I would advocate for a change, even though it's not part of Bill C-24, but still is part of the set of legislation that we're dealing with respect to C6. With that, I want to move on to another area, which is the fees issue. And under regulations, changes made by the previous government, fees were increased to such a degree that a family of 4 could expect to spend nearly $1,500 on citizenship processing fees. And on top of that, there's a $100 right of citizenship fee as well. For many families, this is equivalent to greater than a month's rent. Is significant in terms of that. So I wonder whether or not the government has any plans to examine the high fee structure and any action that the minister might be undertaking to correct that.
I understand that, as you just pointed out, for certain households, the fee issue can be important. I would say, however, that we have, in the way we have presented C6, we have responded to every item we committed to do in our platform and in my mandate letter, and neither the platform nor the mandate letter referred to fees. So this is something that over time we will examine, but we have not made any commitment to change those fees, and there was no fee change in the bill.
I see. So is the minister saying that if it wasn't committed in the election campaign or in the platform, those are the things that this government would not consider, even if it was brought to his attention, and even though he may actually support those kinds of changes?
No, that is not what I am saying. I think anything that is in my mandate letter is something we are committed to do, but we may well do things beyond that. And there's no reason why we cannot. So I'm saying fees are something we could consider in the future, whether it's not a part of the mandate letter. It does not preclude us considering changes in the future, but it's not a part of this new Bill C6.
All right. I would urge the minister to look into this issue, and hopefully action will be forthcoming. Let me move on to another issue. Bill C-24 eliminated the right to a judicial hearing for anyone who was able to have their citizenship revoked. Those involved with the civil liberties movement are calling on the government to make changes in this regard. Bill C-6 leaves this provision untouched, and so would the minister agree with the Canadian Bar Association that someone who is about to lose their citizenship should always have the right to a hearing before an independent and impartial decision maker?
As I said in my speech in the House on C6, a general point is that we are always open to amendments if those amendments improve the bill. We're not sitting here saying it's perfect. We will not contemplate any amendments. And more specifically, what I said was that that point having been drawn to my attention, I said I would also be open to consider amendments which provided greater right to appeal for those whose citizenship is revoked on grounds of false information provided. I won't go further than that because I think this committee will hear from the CBA and from other witnesses who might themselves have ideas on how to proceed in this area. But certainly I've said I'm open to amendment in that area.
Thank you, Minister. Ms. Zaid?
Thank you, Chair. Thank you, Minister, for joining us today as we examine this important legislation, Bill C6. This is a very important issue for me and for my constituents in the riding of Scarborough Centre. After the Conservatives passed Bill C-24, effectively creating 2 tiers of Canadian citizenships, as a mother, I had to explain to my 2 sons why they were now second-class citizens in the country. They have grown up and they love that country. This is wrong, and it goes against the fundamental values of the country that has shaped them into fine young men they have become. So both as a mother, as a parliamentarian, and as a Canadian, I am proud to see the integrity of Canadian citizenship restored. Could you please explain why it is so important to defend the integrity of Canadian citizenship, which is a beacon for people around the world?
Well, thank you. And I appreciate that question. I certainly agree with the sentiment expressed. As you know, in the election campaign, that was one of the major issues that we argued. The Prime Minister argued, I argued, many of us argued that a Canadian is a Canadian is a Canadian. We do not believe there should be 2 tiers of citizenship. We believe all citizens are equal. And that was the reason that we repealed this provision whereby somebody's citizenship could be removed, but only if he or she was a dual citizen. We believe that there should be only one class of citizen. And so that is why that was actually the first item on this bill, which I mentioned in my abbreviated opening remarks.
Thank you. I've heard from a number of permanent residents in my riding, and as I meet them every day in my constituency office, who are ready to apply for Canadian citizenship but have had to wait longer because of the previous government's lengthened waiting period. So these are people, they have worked hard, they pay their taxes and are making a valuable contribution to the economy of our society. Now they want to join our Canadian family. Could you please discuss how Bill C6 will help these people join our Canadian family sooner?
Well, thank you. You know, I'm not hesitant to change things which the previous government did, with which we disagree, but neither am I wishing to change everything, and I would also be fine with giving credit where credit is due. And I do think that one of the areas where we have improved is the processing time for citizenship, and that partly as a result of changes made by the previous government, the processing time for citizenship is now 12 months for those who apply today. And for those legacy cases that are from the past, it has been longer, but I'm told that those legacy cases will be fully resolved by the end of this year, right? And so I think we will then have a across-the-board standard for processing time for citizenship of 12 months, which is, 6 months would be better, but 12 months is better than 31 months, which is what it used to be. So I think some progress has been made. And the other thing that we are doing, which will speed up the process, is the length of time that one has to be in the country. And so it's 1 year less. So an individual can become a citizen 1 year earlier than before under this bill. And once applying to be a citizen, the processing time is 1 year. So there's been some improvement. And I think as well, the reduced barriers that I mentioned also will make it easier for individuals to become citizens.
I represent a riding which has a very heavy Filipino and Gujarati population. So I know several of the Filipino and Gujarati families that have brought their parents to Canada to help them look after their children. These grandparents are providing valuable child care by looking after their grandkids, allowing both their parents to work and contribute to Canada's economy. Could you please explain how the changes in the language proficiency requirements and the age range in Bill C6 will impact these families?
Well, if you're talking about parents and grandparents being brought into the country as permanent residents, then our move to raise the number of applicants from 5,000 per year to 10,000 a year will help on that front. In terms of language requirements, should they want to become citizens, then if they are in the age range of 55 to 64, then the provisions in our bill will provide some help to that group.
What is the profile of the 55 to 64 age group?
The profile, I don't know what what does that mean?
Do we have any statistics that of the people who apply, how many are in that age range of 55 to 64?
To become citizens?
Yes.
8% of those who apply to become citizens are in the age range 55 to 64.
And what about the youth between the age range of 14 to 18?
Also 8%.
Also 8%. That's just a coincidence, I guess. But the younger group, 14 to 18, is 8%. The older group, 55 to 64,
Is 8%?
is also 8%.
Okay.
1 minute. 1 minute.
Okay, 1 minute. Okay. Do we have any figures in terms of how many additional people will be eligible to apply for Canadian citizenship by reducing 1 year the time permanent resident must be physically present before qualifying for citizenship?
Certainly more would be eligible. I don't have a number. We could try to get back to you on that. We don't have a precise number. But obviously, if you reduce the number of years you have to be in the country before you can apply, then there will be some people who will become eligible earlier than otherwise, earlier than before. We don't know that number, but we could get back to you with it.
That would be. Thank you, Minister.
Thank you. Mr. Tilson, 5 minutes.
Mr. Chairman, I have a couple of questions that continue on from the questions that Ms. Rempel asked to the Minister. But these questions I would like to direct to Ms. Tapley or one of the other members of the department. And that is, the first one is, has the department done an economic analysis of the impact on the labor market of the narrowing of the age range required for language proficiency?
Mr. Chair, to continue on with the previous questions, a full economic analysis of changes on language is not something the department's undertaken, but we have looked at other issues around language. And one of the things that we look at, of course, are where are our comparator countries on requirements for the citizenship tests that they provide. So if we look to the United States, applicants 18 and plus must provide a language proficiency test or take a language proficiency test, which determines the applicant's ability to read, write, and speak and understand English. However, They're exempt from that if they're over the age of 50 and have spent 20 years in the U.S., or if over the age of 55 and spent 15 years in the U.S. In Australia, the age range is 18 to 59.
Yeah, so Mr. Chairman, I guess the answer is no, and that gives me some concern because really this is all about making sure that these new people will have jobs. And yet, if they don't fit into the labor market, there is a problem. So my second question, Ms. Tapley, is what is the general participation rate of the permanent residents in the labor force?
I'm doing this off the top of my head, Mr. Chair, but I think the general participation rate of permanent residents in the labor force is close to 80%, somewhere between 75 and 80%, Mr. Chair.
And Mr. Chairman, through you, Mr. Chairman, do you have statistics by age range, including those for teens and for those over 55? The Minister gave some answer to that, but perhaps you could elaborate whether you have statistics on the by age range.
Of the composition of permanent residents in the labor force by age range, I don't have them with me, Mr. Chair. I'm sorry.
Mr. McCallum,
would you be able to provide that to the committee?
Excuse me?
I'm just asking Ms. Tapley, would you be able to provide that to the committee?
I'd be happy to provide that to the committee, Mr. Chair.
Mr. Minister, do you not agree that the language proficiency requirements for minors would also be of benefit to teenagers in their education? In other words, if they're going to go to school, they have to be able to understand what's going on in school, either in French or in English.
I think my concerns of about 16-year-olds are limited, that I am sure that a 16-year-old new Canadian will have ample opportunity to learn English or French and will do so, as we see throughout our country for many years, if not forever.
How are you going to do that?
I think it's in the economic interest of the person to do that. I think they learn it at school. I think they learn it through their friends. There's a myriad of reasons why the average 16-year-old will find it advantageous to learn English or French.
What I'm interested in, Mr. Chairman, if to the Minister, is that, the age is being increased from 14 to 16, and people come to this country, young children come to this country, and they can't speak English, and yet they're going to be going to school. So I'm interested as to what, you're raising it to 16, so I'm interested for under 16, what programs you will have for them to learn English or French.
20 seconds.
Well, I'll use my 20 seconds just to correct the number. It's 18, not 16.
18, I apologize. It is 18. Well, that's even a better example.
But I'm out of time.
Oh, Mr. Minister, shame on you. Thank you.
Mr. Tabarra, 5 minutes.
Mr. Chair, and thank you, Minister, for being here. Minister, you appeared in the committee on February 23rd, and I congratulate you for restoring the federal interim health program for refugees. And I just want to thank you once again for restoring that. And then I asked you when you would reintroduce the legislation to repeal BC 24, and then you responded in the coming days and not very many. And then 2 days later, you introduced Bill C6. So again, I want to congratulate you for that.
Well, thank you very much.
I have a couple.
My pleasure.
Thank you. I have a couple concerns. There are a number of things about the act that we might want to look into. Some are within the scope of this legislation, and some that are not in this, and could be subject to amendment. And the issue, the concern I want to raise is have your department talked about second-generation Canadians born abroad, and how maybe they can have a pathway to citizenship?
There is nothing in this bill that talks about that. There is reference to lost Canadians. Perhaps you could elaborate on your point.
I think it was under Bill, maybe I have the wrong one. I'll just go on to my second question then. My second question is there was a constituent that came, again this will be out of the scope as well here I think. Just one second. Okay, my third question here, I'll ask this one. I got an email from an engineer in my riding who became a permanent resident in 2013 and then went back to the UK for a few months to finish their university degree. Moved in Canada permanently in 2014, and he was so eager to apply for citizenship as soon as possible after C6 becomes law. As mentioned earlier, my office has received a number of emails. Minister, can you have an estimate of the length of time that it might take to bring C6 to introduce the implementation once it's enacted?
Okay, well, we obviously would like to get C6 through as quickly as possible, subject to the will of Parliament. And the first step involves your committee, and you will have witnesses, and I don't know exactly when you will get it back to the House of Commons, but I'm hoping that won't take too long. And then it goes to the Senate, and the Senate is a little bit more difficult to predict, given that we don't have a majority in the Senate, but we do in the House. So we will then have to speak to senators and hope that they will pass the bill, and that's the next stage. And then after that, it will receive royal assent, and different aspects of the bill will be implemented at different speeds. I think the issue of time spent in the country, there will be some delay in implementing the bill in order to prevent the buildup in backlogs resulting from this change. Is that correct? Yes.
Another question, I think it's in the scope. I had another constituent come in. I think it relates to this bill, and just correct me if I'm wrong. He's an individual that works overseas, and his family is all Canadian here. They all have, his wife and his children are Canadian, but he's traveling quite often overseas, and he's unable to stay within Canada for for the time frame to become a citizen. Is there any way that we can look at individuals, maybe if they're working for a Canadian organization or an academic institution, that they can still have a pathway to citizenship?
30 seconds, Minister.
We do require physical presence in Canada. We've reduced that requirement in terms of the number of years, but we are concerned that people who become citizens be true citizens and not citizens of convenience. So we have retained that, although I know in some cases it does cause hardship, but this is something that we have retained while at the same time shortening the number of years.
Thank you.
Thank you, Minister. Mr. Soroya, 5 minutes, please.
Thank you, Mr. Chair, and thank you, Minister and the panel. Mr. Minister, the question was from David. The teen who lives in the country, he's 18 years old or 17 years old or 16 years old, before he applied for the citizenship. Obviously, he's lived here 3+ years, 4 years. What do you think the person who does go to school doesn't have the knowledge of either one of the languages? Something is wrong with that situation?
Well, look, I'm not concerned about the 16-year-old. I think most 16-year-olds can speak English or French. I think if they don't, they will learn it at school. They will learn it from their friends. They will take lessons sometimes provided by the government for language. So I think the number of 16-year-olds who don't learn to speak good English or French is limited. I think the case at the older end of the age spectrum may be more serious, but I think a young person, it would be very unusual for that person not to learn English or French, I would say.
Why would we change if this is the case?
Well, I think we often have rules applied to the age of majority. I think we thought that it was just fine the way it had been, so we were changing it back to the way it was, where the cutoff age was 18, which is often the case because that's the age at which a person is judged to be an adult. So I don't think it is terribly important one way or the other, because I do believe that if you're a 16-year-old or a 15-year-old, one thing you're going to do is learn English or French, if you don't know it already.
My next question, Mr. Chair, through you to Minister, regarding the citizenship, revoking the citizenship, through Bill C-24, convicted terrorist Zakaria Amara lost his Canadianship. Is that correct? Bill C-24.
What's the question?
Through Bill C-24, convicted terrorist Zakaria Amara lost his Canadianship. Is that correct?
Through the previous bill?
Yes.
Yes.
And through Bill C-6, Zakaria Amara stand to regain his Canadian citizenship. Is that also correct?
Yes.
Is he going to apply for the citizenship?
He doesn't. He is not required to.
So he automatically becomes citizenship sitting in the jail?
He automatically has his citizenship reinstated. This is for purposes of consistency. If we don't think that it's right for his citizenship to be revoked for those reasons, that principle should be applied generally.
Mr. Minister, as you said, Canadian is a Canadian is a Canadian. As also, same thing should apply for a terrorist is a terrorist is a terrorist. Even his own people don't want to live that kind of person in their own backyard either. My next question is through BLC 6. Actually, you already answered it. Another one of the convicted Toronto 18 terrorist, Gaia, who plead guilty to terrorist charges in relation to the Toronto 18 terror plot and was serving 12-year sentence, was guaranteed day parole in January of this year. Although subject to certain conditions, he is now able to walk freely on Canadian street. In contrast, the previous Conservative government was taking the legal steps necessary to strip him of his Canadian citizenship. How is allowing a convicted terrorist to walk freely on Canadian streets not a security threat?
I have confidence in our legal authorities and their ability to monitor people who may be security threats.
Given the fact
30 seconds.
Given the fact this government believe in consulting the public for all these things, all these changes, since this is a huge changes, did we consult the public on this issue?
We consulted a very broad public, which is called the population of Canada, in the last election, and they voted for us.
Thank you. Ms. Kwan, 3 minutes.
Thank you very much. The Minister...
Mistake. Mr. Asasi, 5 minutes.
Thank you, Mr. Minister. I just wanted to join my other colleagues on this committee to once again thank you for taking time out of your busy schedule with your officials to be here.
Even though I was late, my apologies again.
Also, I wanted to thank you for the energy you've brought to the task and for the important and timely changes that you are making to the Citizenship Act. This was obviously a very lively issue in my riding of Willowdale, so very nice to see that some of the excesses of Bill C-24 have been addressed in Bill C-6. Now, if I could focus my question on credit which is being provided to those who are temporary residents in this country and intend to apply for citizenship. I find that to be a very useful change. And I have every confidence that it will have a discernible impact on attracting some of the best and brightest from around the world to apply for Canadian citizenship. Of course, one can think of international students or, of course, people who are experienced workers. Now, I had an opportunity to look at the changes that are being contemplated and to compare them to provisions that are also available in the American and Australian citizenship system. My colleague had a chance to ask you whether there was some consideration of providing more than 50% credit for that period. My question was whether there was any consideration of having a cap that would not be for 365 days, but actually for a 2-year period, and whether that's something that was contemplated.
What was that? You only have to have 3 years for citizenship, so that would be 2 out of 3. It's something, again, these things are all debatable, but we thought that where we went was sufficient. And you mentioned international students. I might just add the point that, yes, we've moved to reinstate the 50% credit for citizenship, but more important is access to permanent residence. And I have said, and here's an example of something that's not in my mandate letter, not in my platform, but I still want to do it, which is to increase the points under express entry for international students to give them greater access to permanent residence. So my aim is to help international students not just through reinstatement of the 50% credit for citizenship, but also by improving their access to permanent residence through the express entry system, because I don't think there's any group of people more positive for what good Canadians they will become than international students, because they're educated, they know French or English, and they know something about the country. So this is a double courting of them, if you will, one through this Bill C6 to reinstate the 50% credit, but also through something that hasn't happened yet, but hopefully soon, to make it easier for them to become permanent residents.
Thank you. The second question I had is, how would the physical presence period be determined for refugee claimants? Because I'm not too clear on that particular issue.
I believe it would be the same way. Is that correct, or is there a difference?
Mr. Chair, if I may, it's, I think with respect to counting time here before you're a permanent resident. And so for asylum claimants who are within Canada, once there's been a positive determination, then it would be possible to count that time here as a protected person before they become, or up to including a permanent resident. And that time could apply for citizenship. But the time that they're here until they have a positive determination on that status would not count.
Thank you. That concludes
30
my
seconds.
questions.
Thank you. Ms. Kwan, 3 minutes.
Thank you very much, Mr. Chair. The minister mentioned about two-tier citizenship. A citizen is a citizen is a citizen. And now the issue of lost Canadians, I think, has been brought to the minister's attention, and there are great concern around this issue. And essentially, the current legislation denies Canadians born abroad the ability to pass on citizenship to their children, even in the event that there's significant contribution to Canada and to Canadians. So I wonder whether or not the minister would be willing to entertain amendments to this effect, if not to Bill C6, to a separate amendment. My former colleague, Olivia Chow, had actually tabled a private member's bill in this regard, and whether or not the government would be interested in entertaining such a move.
Well, before I answer that question, I think it might be good for Ms. Hubers to explain the context in a bit of detail.
Okay.
So there's nothing in Bill C6 that talks about the first-generation limit, but there is in the law a first-generation limit that applies to children born abroad to a Canadian citizen. There were a number of reforms done that gave citizenship back to lost Canadians. The first one was in Bill C37 in 2009, and then there were additional changes in C24 that gave citizenship back, or gave it for the first time, to a number of other lost Canadians. So there were a number of individuals who were fixed by those provisions. For those who are impacted now in terms of, they themselves are first generation born abroad, and they have a child abroad who's therefore not eligible for citizenship by descent, there are some avenues available to them. For example, they can sponsor that child for permanent residence to Canada, and if the child is stateless because they don't have access to any other citizenship, then there's a grant in the Citizenship Act for stateless children of Canadians.
I guess I won't spend time talking about that. I was looking to see what the minister's point of view was with respect to that, because for a number of Canadians, that is still deficient, and there's still a number of people who are still caught in this lost Canadians category. But I only have 3 minutes, so I'm going to move on to another issue. I have 30 seconds. I want to just touch on then very quickly on the language issue. The LINK program has been cut in terms of their funding. VCC in my riding particularly has faced a 8.5% cut. And so we talked about languages and the importance of that. Will the minister actually reinstate the funding cuts for LINK programs across the country?
There's very little in terms of welcoming newcomers more important than language. I don't know what fraction, what percentage of our settlement funding?
It's about a third.
A third goes to language. And as a consequence of the refugee initiative, the total funding for language training has gone up, not down. It's possible it's gone down in your riding. I don't deny that. It varies somewhat across the country. But overall language funding nationally has gone up. And so, we want to continue to make that language funding very high because we understand the importance of language.
Thank you. Minister, under previous Liberal governments, residents without legal temporary residency were allowed to include the time spent in Canada prior to obtaining permanent residency towards their residency requirement. This would include refugee claimants, persons whose sponsorship application had been approved, and those whose applications for permanent residency on humanitarian considerations had been approved. I'm concerned that C6, as worded in Section 7.1.001A, does not consider this time as residency. I assume that you would be amenable to a friendly amendment that would clarify this issue in cases of refugee claimant sponsorship, humanitarian compassionate cases?
Okay. I would perhaps consider that, but first of all, I would want to have a clearer understanding of it. This is a fairly technical issue, which Ms. Hubers, I would ask to comment on.
So you're right on the Act the way it was before, as it was before. It did allow for anyone who was in Canada prior to becoming a permanent resident to count that time. It didn't stipulate whether it had to be lawful residents or not. The change here does reinstore the ability to have a non-permanent resident time, but it does stipulate that it's time as a temporary resident or as a protected person. But as was explained earlier, an individual who is an asylum claimant and is then successful becomes a protected person, and they can then count that time towards their citizenship credit once they become a permanent resident and apply for citizenship. So they still do benefit.
Okay, so I guess my answer to your question, I'd be willing to think about it more, but my first reaction is, as a matter of principle, I don't think we want to give credit for time if the person is here illegally. I don't think we want to give credit for illegal time. I'm sure there are at least some members, I see them nodding their heads on that issue. So I'm not sure that the bill currently does more than just rule out credit for time spent if you're here illegally. Is that right?
Yeah. Anyone who's here as a temporary resident, whether as a visitor, worker, student, could count that time. Likewise, someone who's here as a protected person, once they get that status, they can count that time as well.
Thank you. And a final question. Minister, the previous Conservative government gave your predecessor the unfettered discretion to grant citizenship. C6 does not reinstate the necessity of the Governor and Council's approval for ministerial granting of citizenship. C6, as written, doesn't provide the scope to make such an amendment. Under what circumstances other than humanitarian compassionate discretion you already had, would you override or short-circuit the arm's-length citizenship process with its prerequisite qualifications and checks? And the question is, fundamentally, do you believe that a politician in the executive branch of government should have the unchecked power of granting citizenship?
Well, first of all, I have, with great enthusiasm, limited my power to take away citizenship, because one of the essential thrusts of the bill is that the Minister of Immigration will no longer have the power to revoke citizenship for people convicted of certain crimes. As for the ability to award citizenship,
There's two criteria. One is for exceptional service to Canada, and one is to alleviate cases of special and unusual hardship. Those are the two criteria under which the minister can grant citizenship to an individual.
So the question is, previously it required Governor and Council approval. That's no longer the case. Is there thought that perhaps we would move back to the previous system that at least provided some sort of check?
I'm not in the pursuit of unfettered powers. I was not aware of that. I think that there could be a case for that, but the main thing that this bill does is to remove the power of the minister to revoke citizenship in the case of people convicted of certain crimes. And on that issue, I'm very content. That was the intent from the beginning. On the other issue, in terms of limitations on the minister's power to name citizens, I'll certainly look into that. But I think the main issue here was to limit the minister my ability to revoke citizenship, and that is clearly accomplished in this bill.
Thank you, Minister. Thank you for appearing before our committee. And we'll suspend for 2 to 3 minutes while the Minister departs, and the meeting will continue picking up where we left off in approximately 2 to 3 minutes. Thank you. The meeting will resume. Mr. Sarai, 7 minutes.
Many of my constituents have concerns in letting terrorists and those participating or convicted in it prior from coming into Canada or getting citizenship. I'd like to confirm that we can still revoke citizenship of someone who lies in the process of getting citizenship, i.e. a terrorist who would have his or her citizenship revoked if he had lied or hid their connections to illegal groups. Is that correct?
That's correct, Mr. Chair.
So those involved in terrorism who lied during application will have their citizenship revoked, and that ability still remains.
Bill C6 doesn't change any of the provisions related to revocation for reasons of fraud or those who lied on initial applications. Nothing in this bill would change that.
Good. My next question goes more to the tests for citizenship. Are the changes to the tests for citizenship, will they be more reflective in which the key component of the test will be the Charter of Rights? I just want to ensure, is that one of the ideas of the new book or the new test? Will the Charter of Rights be a key component in that?
Mr. Chair, the test for citizenship is based on a series of prescribed factors which are in regulations, including knowledge of certainly the Charter of Rights, but also Canadian history, Canadian society, the rights and responsibilities of citizenship. And I think what the Minister has indicated is that he's looking at updating Discover Canada, which is the guide to citizenship, and making sure that that's current and reflective of those factors.
So my concern is sometimes we all value, obviously, rights when they reflect our own rights or rights that we prescribe to or not. But it would be very important and I think very significant where new citizens are shown and taught that even if the rights those rights are not, or those practices are not compliant with your own values or faith, that protecting and cherishing and allowing others to have those rights is very important. And I would emphasize if the department could look at that and consider that in the new test results, that is a key component, that not only having the right to practice your own faith and your own rights, but is also very important to cherish others' rights to practice, even if they are different or not in concurrence with your own. And I'm just hoping that you will look into that when creating your new book.
Mr. Chair, we think this is a very important point, and many of those elements are in Discover Canada now. And so the test, which is 20 questions, is based on the content in Discover Canada, and that would certainly be something that we would look to retain.
My next question is, has the Minister considered reducing the time needed to getting citizenship to the actual 3 years? So I'm a little confused, and perhaps I should have read the bill a bit better, but right now it's going to 3 of the 5. Can the person, once they've done their 3 years, so if they continuously stayed here for 3 years, right away immediately apply, or do they have to wait for the 5-year process?
They can apply as soon as they've met that 3-year requirement.
My next question, I know it's been slightly asked before on the actual demographics that are 55 to 64, and those were 8% that usually apply. But how many more would be eligible for citizenship? Have we been able to study that and see how many that would have perhaps failed the test or hesitated from taking the test, or the language proficiency, particularly between 55 and 64 and the younger age of, I believe it was 14 to 18. How many more permanent residents would be eligible for citizenship by this change?
Mr. Chair, we monitor pass rates on the citizenship test pretty closely, and so I can say that there's an 87% pass rate on the citizenship test of people taking it for the first time. And as the Minister indicated, individuals can take the test a second time if they're not successful the first time, and when that happens, we bring the pass rate over to over 90%. And indeed, there is a third safeguard in the system, and that's you can have a hearing to ascertain knowledge if you're not successful either on the first or the second try.
My question is more of a survey because I have some constituents who won't take the test out of fear that they will not be able to pass, whether it's the language proficiency or the knowledge-based test. They've been asking when the changes are coming in. So I wanted to know if the departments undertook any survey or poll to see the actual amount of people that would apply in addition to what they would expect otherwise. So somebody, if they already on their own think they will not pass a level 4 English requirement, may not even go to do the test. So therefore, you won't know a pass or failure rate. But how many more people do you believe would apply for citizenship with this new measure? If there's any poll or study conducted by the department?
It's pretty difficult to isolate certain factors, and I appreciate the question, Mr. Chair, but I can say, in general, we have a very high naturalization rate. It's about 85%. And so of those 15% who don't seek citizenship over, a fairly long period of time, there are a number of reasons for that. Some of that has to do with dual citizens or host country, people's own desires. There are a lot of factors. But in terms of being able to analyze those who are afraid to take the test, I'm afraid I don't have much on that.
Mr. Sarai, 45 seconds.
Sure. The last one is just for students. Is there an ability that students who are here can get more of a credit rather than 50%, as when a student is here, they're probably the most integrated of resident at the time. They're participating in school, they're learning the language, learning the culture from the grassroots, they're staying in premises. Is there an ability or a thought to increasing that time for students, particularly to greater than 50%, more towards 75 or 100%?
Mr. Chairman, I think what the minister had said when he was here was, he felt that this struck an appropriate balance, and given the requirements in terms of physical presence in Canada had changed to 3 of 5 years, having 50% to accumulate to a maximum of a year, he felt was a very good balance with respect to the old system.
Thank you, Ms. Tapley. Mr. Tilson, 7 minutes.
Yes, Mr. Chairman, I'll be sharing my time with Ms. Rempel. I have some questions on sections 11 and 12 of the bill, which has to do with the seizure of documents. And my first question is, what sorts of documents are envisioned with respect to the seizure of these documents?
So this could be passports, for example. So every applicant is interviewed when they come in to take the test, and at that point we look at their passports to verify their absences from Canada against their declared absences to see if they've been physically present. So if there's some evidence that there may have been some tampering with those passports, this would give the authority to a citizenship officer to seize that document.
And how much discretion, Mr. Chairman, will be given to the officials with relation to this new, it's a new power?
There is an authority to create regulations, so in the bill. So there would be regulations which would describe the prescribed factors that would cause the document to be.
Is there any hint what the regulations are going to be? You're going to be writing them.
The bill hasn't passed yet.
All right. That's a good answer. What recourse will there be to the individual if his or her documents are seized?
Again, those would be details that would be worked out in the regulations.
What factors would trigger a seizure, Mr. Chairman?
There has to be a reasonable grounds to believe that the document is fraudulent.
So all this will be in the regulations?
Well, in the Act it says that there has to be a reasonable grounds to believe that the document is fraudulent, and then the regulations would prescribe the factors that could go into that and the dealing with the detained document.
Okay. Ms. Rempel.
Mr. Chairman, if I may, just on that question, these are very similar to powers that are in the Immigration and Refugee Protection Act, that they already exist in that Act. And so we would look to those regulations to inform what we'll be doing on these regulations as well.
Well, Mr. Tilson stole a majority of my question, but your remark was satisfactory. My question relates to processes to support the changes in this bill. This bill will create changes to some of the processes by which newcomers to Canada can obtain citizenship. And oftentimes, across party lines, one of the things that happens in our offices is that we get people, constituents coming in, asking questions about their applications. Most of the time, they're pretty straightforward inquiries. We'll say, you know what, you're within the normal processing times, et cetera. But every once in a while, there's a situation where we'll have a constituent come in that can verify and say, look, we know that the visa officer didn't review this piece of information, or they have a complicated case with an overseas embassy. And what will happen in that situation is that we will call the dedicated 1844 number for members of parliament, and the response that we'll get is, well, you need to, talk to another contact in Ottawa, which usually means somebody in the minister's office. My understanding is that there's a department called the Ministerial Inquiry Division, I know this for a fact, that we also have access to as MPs, which is a nonpartisan service for MPs to phone in and ask for clarification on these types of cases. There's been some confusion as to whether or not MPs will have access to the Ministerial Inquiry Division. My understanding is that there will only be one number to call now. So my question is will staff from the Ministerial Inquiry Division be available through this new number? So in effect, we're not losing direct access to the Ministerial Inquiry Division.
Mr. Chairman, I'm sorry, I don't know. I'd be happy to get back to you on that point, but I don't have that information.
Mr. Chair, if I may, I would love to have that information presented to committee, because there's been a lot of lack of clarity from your department on this. I think that this is an issue that's going to come up in all of our caucus meetings, and certainly just as a best practice, I firmly, and I think everyone around this table firmly believes that we should let visa officers do their jobs, that MPs shouldn't be, interfering in that sort of thing. But when we do have to make legitimate inquiries, we shouldn't be adding an extra layer of red tape. What's been expressed to us right now is that all of our inquiries will be going through this one particular line, which it sounds like they would be calling and asking the Ministerial Inquiry Division on our behalf, rather than having staff there available to ask ministry. And this will gum up the system. We don't have a lot of resources in our office to do these sorts of things. So my advice to you would be to really consider the impact on that to members of parliaments being able to service their constituents. It sounds a little short-sighted if that's the case, and I think everyone around this table would like to have some clarity on that as well.
Mr. Chair, we're happy to come back to the committee on that.
Thank you.
Excellent. Do I still have some time?
Yes, you do.
Excellent. I just want to go back to the language training component.
Excuse me,
as well.
just before. I'm sorry, Ms. Rempel. This issue is so important. I think we should ask the staff when they've been briefed on this to come back before our deliberations on this bill, and because it does affect the bill, it affects the whole immigration process. So I would ask that you direct, but you don't dismiss these witnesses, and that you ask them to come back and brief us further on that issue.
That was not part of what was decided by the subcommittee, but if you'd like to make a motion.
Well, I won't do it now, but...
Thank you. Ms. Rempel, sorry about the interruption, but
yeah,
since it was your colleague, we allowed him the leeway.
I would just, with the remainder of my time also, and I hope in a very non-partisan spirit, and to my colleagues who may be new and just starting the process of dealing with casework, reemphasize how important it is for us to have access, because what happens is when we phone this 1844 number, oftentimes the response that we'll get is we can't help you, because them being the central processing unit would essentially allow them to overturn somebody's decision. That's not what we want. But every once in a while, if there's a new piece of evidence that a constituent has come in, there legitimately has been times where evidence has been lost in the mail, and we need to have a reconsideration on a ruling. They're not in a position to be able to do that. And, for example, if I can give an example of something where we would intervene, I had a constituent where her husband was the sponsor on her citizenship application, and her daughter, they were about to take the oath, and he committed suicide, and the ruling was that he could not grant citizenship. So that's where we worked through that department to overcome that issue because the visa officer couldn't overturn the ruling. So these are the sorts of cases that we are involved in, and from the bottom of my heart and to my colleagues across the aisle, I strongly recommend against removing our access into that division. It's going to make your life a lot more difficult. It's going to gum up the system for your officers as well as for us. So if anything, I would recommend better training for new MPs on how to use those services and in what situations.
Thank you, Ms. Rimpel.
That would be really helpful.
Mr. Chairman, I would move that the staff, the department, be invited to return before the end of the deliberations of Bill C6 to further brief the committee on the topic that's just been raised by Ms. Rempel. And if it requires further time on the bill, that would be added to the time.
Ms. Zaid?
This was not in our schedule. I think maybe we can discuss it in the subcommittee.
Mr. Chairman, I've made a motion. I made a motion. I expect we're going to have a vote on it or debate.
I believe we're into debate, but Ms. Zaid?
Yes. So this was not in our schedule. I think now we have to finish with the officials here, and maybe this can be taken in the subcommittee.
Are you suggesting that the department come back to a subcommittee? No. The department would come back to this committee, and we would, this is a most important issue. I don't know whether you've had calls, Ms. Zaid, to your
the
office.
officials will provide the response on that.
Through the chair, please.
Yeah, they will provide a written submission on that.
Mr.
This is a good topic. It's not partisan.
Ms. Kwan, you are next on the list.
Thank you very much, Mr. Chair. I would actually support this motion, and I think we can dispense with it fairly quickly. I think it is an important issue for us to get clarity on what the changes are. We had heard news about this, had been hearing about rumors around this change. I had written a letter, actually an open letter to the minister, making inquiries around that to see what the changes were. Constituency offices were very anxious, rightfully so, if there were changes, to see what it meant in terms of them being able to help their constituents address cases. And in that regard, it would be useful as well to actually get information with respect to the changes around embassy offices, because that change included the constituency office not being able to contact the local embassy offices for information about cases. So I would welcome this opportunity, but I don't really want to get into a full debate into this at this juncture. So hopefully we can vote on this, and then I can get on with my other questions to the officials related to Bill C6.
Ms. Rempel?
Mr. Chair, to my colleagues across the aisle, this is not meant to be partisan. This is we're just simply asking for a briefing on clarity on how to, and your staff are shaking their head at me, which I find extremely unprofessional. This is simply to get a briefing on how this process will work. I would assume this would come up in your caucus meeting as well. We've had different messages from the minister's office, from the department on what's happening, and we would just like some clarity on this process. And frankly, if you overturn this, I just ask what's there to hide? This is just simply a briefing on the process change, and that's all.
Ms. Zaid?
Yeah, I would add, there was an email which was sent out on April 5th to all the members, and it says access to IRCC continues uninterrupted. Members of Parliament have direct access to the dedicated line to the Department of Immigration, Refugees and Citizenship Canada. All MP case inquiries are handled directly by the dedicated division, which is separate from the general public. By the end of the year, we will implement an inquiry system under one central number to manage all inquiries related to IRCC, which will remain solely available to members of Parliament. This system will further ensure that members of Parliament receive the most expedient and informative service possible to assist them in helping their constituents and managing their cases. So this came on April 5th.
Thank you for that information. Mr. Asasi?
I just wanted to remind my colleagues here, and in particular Ms. Rempel, that as you know full well, the purpose of today's hearing and having the officials here was to discuss Bill C6. Further to that, as you know, the officials have kindly agreed and undertaken to provide us with the information that you have asked, so I don't quite understand why you think it would be necessary for these officials to once again appear before this committee.
Thank you. Ms. Rempel.
On that point, the email that Ms. Zahid read out talks about the centralization of access for members of parliament into one number. What's not clear from that is whether or not staff from the Ministerial Inquiries Division, who have the authority to look at things like reconsiderations of rulings on citizenship decisions, as well as, for example, dealing with overseas embassies, and these are scopes of responsibility that the staff that man the current central line at the central processing unit do not have. So what's not clear in that email is whether or not, as members of parliament, we will still have access to the level of service and the scope of responsibility of the staff that the Ministerial Inquiry Division provide. The way I read that email, and many of my colleagues did, and your caucus included, it looks like we would have to phone a number and have a staff member basically act as a middleman on there. And that's, in my opinion, not the best process. I would like more information on why this decision was made. That's simple. And also, as my comment to the officials were, my recommendation would be, rather than going to a middleman situation, that we actually have better training for new caucus members. So perhaps if the Ministerial Inquiry Division is getting a bunch of requests that are, you know, out of scope or something like that, that there's some training provided. Your question about why this is happening now, the changes to Bill C-6 will impact your offices. You are going to have a lot of questions from constituents on how these new rulings might apply retroactively, or if they apply to cases already in there. We're going to have a lot of requests. So I really do think that, again, this is not a gotcha situation. Just to have the officials sit here, and whoever the officials may deem to find appropriate to do that, to answer questions, that would be, and I think a lot of our colleagues across party lines would be very interested in that.
Thank you. Mr. Tilson?
Chairman, just a response to a question that was asked from the government as to why would we want the officials to come back. The answer is because we will have questions. They may provide a written response, but we will have questions. For example, my offices, my constituency offices, where we've called embassies on specific questions from our constituents, and the embassies have said, call this general number. This is something new. We've always had assistance from the embassies. We've never had the embassies, and to be fair to the embassies, not all are saying that. Perhaps they haven't heard of this ruling yet, but the embassy, some embassies are saying, we will not speak to you. You will have to call this general number. That's, members of parliament are asked a lot to assist constituents on immigration and other issues. And this just makes our job much more difficult, and it certainly fits into questions that will arise as a result of C6. So the reason why the motion has been made, we may, I expect we will have questions of the staff on whatever responses they're giving to this ruling.
Ms. Eid?
I think that's a matter of process. Right now, we are discussing Bill C6, and we should go ahead with it. That is a matter of discussing a process, and the officials will provide response to that. Maybe we should go into a vote on this motion.
Mr. Asasi.
Yes, first of all, I wanted to reemphasize what Ms. Zahir said. Secondly, I certainly sympathize fully that there are certain aspects of this that may very well be unclear for Ms. Rempel. However, I just wanted to emphasize once again that the officials have kindly agreed to be responsive to the questions that you have put to them and to provide us with that further information. So that having been said, perhaps it would be a whole lot more proper if we awaited the response that the officials will provide us and then revisit this issue at that particular time.
Ms. Rempel?
I acknowledge my colleagues' comments. However, my sense is that this decision has been made without any consultation across party lines. Given your government's, Mr. Chair, given my colleagues' government's commitments to greater consultation, I would say that the opportunity to ask officials on how the process works will provide clarity for our colleagues. Again, the email that came out last week, I think, provided even less clarity, and having them here prior to the end of reading this bill on how these changes will impact the significant changes that are being made to the Citizenship Law or Citizenship Act, I think would be highly beneficial.
Ms. Kwan?
Much. I guess we'll go to a vote on this, and in the anticipation of what the outcome might be, and should the motion be defeated, I would suggest this, that perhaps, Mr. Chair, you on behalf of this committee can extend a request to the minister on our behalf that a briefing be held by the officials for all MPs in their offices to engage in a discussion to see what changes is being proposed, and so that we can all have this information and ask the questions accordingly, and not necessarily coming out of the time of the committee, which I understand there are concerns with respect to that.
Thank you. I'd like to call the vote, and I'll just read through the motion to make sure that we have the wording correct, Mr. Tilson. Staff be invited to return before the end of consideration on Bill C6 to provide a briefing on the process for accessing the Ministerial Inquiry Division. Recorded vote. Recorded vote.
Mr. Chen?
Against.
Mr. Asasi?
Against.
Mr. Sarai?
Against.
Mr. Tabara?
Against.
Ms. Zahid?
Against.
Ms. Rempel?
For.
Mr. Soroya?
For.
Mr. Tilson?
Yes.
Ms. Kwan?
For.
Thank you. The motion is defeated. How much time did Ms. Kwan have left? Kwan, that was...
She hadn't started.
Oh, okay. Sorry. So Ms. Kwan, 7 minutes.
Thank you very much, Mr. Chair. I'd like to first ask the officials this question. How many people fail the language proficiency test and have to go to the second round and then go to the third round before the citizenship court judge?
Just two parts. The process that I had described was the process around the test for knowledge, not the language test itself.
Sorry, yeah.
So on that, 87% of people pass on the first try. So when they take the knowledge test, the 20 questions that are there, they're required to pass 15 of those 20 questions, and 87% of the people do that. When you allow for a second write of the test or a second chance to take the test, the pass rate moves to slightly above 90%. And then following that, they can have a hearing before the public service decision maker, and I'm not sure on what percentage pass after that.
Okay. Yeah. It's a very low percentage. It's around 2% for language and knowledge, one or the other.
So that is to say 2% of the population fail the test?
2% of applicants are refused for language or knowledge.
Okay, thank you. Can the officials advise what is the time delay for people then to go through the different stages and then to get ultimately in front of a citizenship court judge?
So it depends on volumes, obviously, but right now, and we have a service standard in place, which is for applications received on or after April 1st, 2015, that 80% of those will be processed within 12 months, and we are achieving that target. So the first step is that it goes to a case processing center in Sydney. From there, it goes to the local office closest to the individual's home, and at that point, the applicant is called for to write their test. And they have an interview with them, and if they fail the test, then they would go to a second test, and then finally to a hearing with the public servant.
Yes, I understand the process, but I'm just wondering the time frame. So if a person fails a test and they go to the second one, how long do they have to wait? Is it a month, 1 month, 2 months, a year, and ultimately to get to the court judge?
It's within a reasonable period of time, but I think between 2 and 4 weeks they're rescheduled for another test.
So for each of the stages, between 2 to 4 weeks.
I'm not sure exactly between the second test and the hearing.
If we could then get that information for verification at a later time, that would be great. How long is the processing time for applicants that receive a residence questionnaire?
I mean, it's hard to, the service standard in place is for applications received on or after April 1st, 2015. that they're processed within, that 80% of those are processed within 12 months. If someone receives a residence questionnaire, it becomes a non-routine application that is not then subject to that service standard. However, and it's impossible to say exactly how long that will take. Obviously, we do our best to process those as quickly as possible. However, if sometimes as a result of the residence questionnaire information, an officer is able to determine that they do meet the residence requirement, and the case will proceed. However, if there's still a belief that the applicant doesn't meet the residence requirement after reviewing all of the information provided with the residence questionnaire, then the individual would need to go for a hearing with a citizenship judge.
The waiting time used to be somewhere between 36 to 48 months, which is actually quite significant. So I'm curious as to know if we can get an average time then, even if you don't have that information with you at the moment, it would be good to know what is the general average wait time for someone who receives a residence questionnaire and for that process to unfold.
Well, the 80% of the cases will be processed within a year. There are some older cases that have residence questionnaires attached to them that we're dealing with as quickly as possible. And then for any new cases, we try to be more targeted in the information we request. So sometimes we just ask for information about a specific period of time or specific employment rather than issue a residence questionnaire. But sometimes it is necessary to do that, and that does add some time onto processing.
I want to actually ask about the LINK program. The LINK program, as the officials know, is a language programming support for immigrants and refugees across all the sectors, both the NGO sector as well as colleges. Vancouver Community College, which is actually the longest serving community college in providing this kind of service in the country. They have 40 years of experience and is also the largest college that provide for this service. They had, just prior to the budget, received documentation to confirm that their contract would be reduced by 8.5% in their funding for the LINK program. They already have close to 1,000 people on their wait list trying to get into the language, as the minister had identified that language is essential for Canadians to succeed. Language is essential for Canadians to actually become a citizen. But here we are with a huge wait list, with a large influx of refugees coming, immigrants already waiting to try and to get into the LINK program.
30 seconds.
And their funding is being cut. So I wonder whether or not the officials can actually look into this, and how can we address this issue effectively so people can get the funding to provide the services that is so much needed in our communities.
Mr. Chair, if I may, our base funding for settlement services is about $588 million outside of Quebec, and that hasn't changed. It's allocated based on a formula of where immigrants settle. But for this fiscal year, for 2016-17, we're fortunate in that we have additional funds to apply for settlement, and those are being distributed. So an additional approximately $38 million related to Syria, which will help to go a long way to alleviate some of what the member has spoken about. And in addition to that, there were funds announced in Budget 2016 for settlement with respect to increased levels overall, and that too may be helpful in this situation.
Thank you, Ms. Tapley. I'd like to thank the department officials for appearing before the committee today. And the committee will be dealing with committee business. We'll be moving in camera. We'll allow a few minutes for everyone to depart.
Oh.